I think you'll see that she's put together a really nice package of information for us all. So Sherry, probably take about an hour and a half, maybe? If we don't get through it all today, we'll set another date. Okay? But she has a lot of information to do today.
Yes, I
Thank you.
All right. As he said, my name is Sherry Cunningham, and I'm one of the supervising attorneys in the law office of Rachel Ewing, to, for some of you, Lato Ford. You have a packet here with information that I'm going to try to go through and try to introduce you to a lot of terms here. Some of you should have the agenda that I had of the topics that's going to be covered. This is not an in-depth discussion on direct examination or cross or objections, but it is an overview, something to touch on and give you a basis to hopefully start practicing to make it perfect. So starting with direct examination, first, based on the Evidence Code 772, the order of examination starts with direct examination. Then there's cross-examination. And from there, it's redirect and recross up until the judge says you're done. So that's the manner in which the examinations go. So with direct examination, and before we get there, this is already assuming that you have read your fact pattern. You had your facts in your case. What are you trying to show? What witnesses will you call? What's your theory? What's your theme? How are you going to proceed? Because that is going to direct your questions and your objections to control the evidence that comes in. So with direct examination, the primary tool, this is the primary tool for telling your story. What is your story? They haven't met their burden, this person is lying, this person is coaching. Whatever the theory is, that's what you're doing with direct examination. Now sometimes you may not have a direct examination. Maybe you don't want to call any witnesses. Then your primary goal is just to attack whatever evidence that the department is putting on, attacking by cross-examination. And when you read your detention report and your jurisdiction report and all the little LMIs in between, you already know what the statements are. You already know what's going to be said. It is no surprise. So you make your questions from there. Now on that page, on page 1, what you want to do is and these are all suggestions. Everyone has their own style. There are some of us are new looking for styles. There are some of us that are older and we have styles. So this, if it applies to you, then you can use it. Direct examination is based on Evidence Code 760. Now with that, you want to know, how do you do questions? How do you ask form of questions? How do you form your questions, basically? And what I have here is the W's. One W I want to add to that number 1 is who. You want to ask who, what, where, when, how, and explain what it is that they have already said what to. For example, if your fact pattern is talking about current risks and you're at a 2-1 and it's a contest and you're going over the case plan, what was your case plan? What was your case plan? Where did you do your case plan? What did you learn? What examples can you give us from what you learned, or can you give the court? So that's pretty much how you would direct the questions with direct, once you've determined who you're going to help tell the story that you're trying to tell. Then you have to organize your questions, your direct questions. And I do recommend, until you become maybe more seasoned, whatever seasoned means, is to write your questions down. You want to have a bullet point of where you want to go. You want to have headings, and you want to have bullet points in those headings. And if it helps you to write the question down, write them down. But you don't want to just depend on the writing of those questions, so you can't see the witnesses' answer, you can't determine their credibility. But what it does help you with is if you ever get jumbled. Someone says objection, and it's a whole bunch of talking and back and forth, so you don't lose your place. You have a point about where to go with that question. So organize your questions, write them down, and then, then you see right here under organization, when you're asking questions, the loop back method. Sometimes when you have someone on the stand, they may say something more than the question that you asked. So you want to loop back and ask them some of the questions so that you can break it down if it's relevant to that case, if it's relevant to that question. Do anyone have any questions there about direct examination? Okay, so the key thing there really is just to prepare. You need to know your detention report. I can't say that enough. The statements and the people, potential witnesses that are in there. You have to know your JDX report. Look for any inconsistencies. So moving on to, again, with direct questions, direct examination, you want to ask short questions, open-ended, non-leading, and one fact per question. Let that be your model. Practice that, and you should be good on direct examination. And then continuing on page 1, the next thing we go to is cross-examination. This is where you would be either protecting your theory, whatever your theory is. You want to, well, let me back up a little bit. The reason for cross-examination here is kind of twofold. Is to attack the department's evidence, is to show, sometimes it's to impeach, is to show that the evidence that they have, the witness that they have, lacks credibility. You want to cross-examine them on their statements. You want to test that. You have a right to do that. You always want to lead in the question. Lead them down the path that you want to go. And again, you want to ask one question, simple one question, and lead them that way. It would also help you to write down the questions so you can see if your question is leading, or you can test for any objections in your questions, and objections we will get to. So again, that's what you would do on cross-examination. Now sometimes you may not have any questions to ask, and it's okay. You have to determine, did what that person say hurt my case? Did they bring out any bad facts? Did they bring out any surprises? If no questions, Your Honor, and then you can move on with cross-examination.
I know, sitting on the bench for a number of years, and even as a practicing lawyer, you have to be very careful of asking too many questions on cross-examination. You want to know, most of the time you want to know the answer, because sometimes you ask the wrong one question, and all of a sudden you're losing the case. So it's really good to have a good sense for where you're going, what's the answer going to be. Because I saw many times somebody doing a great job on cross-examination but asked one too many questions.
And so to that, the tip would be, never ask a question that you don't already know the answer to. That can blow your case.
And so it's hard for us because we have very limited discovery. It's not like doing a civil case where you've done interrogatories and depositions, and so you're really prepared. So in our situation, we don't have that luxury. So it's just a caveat, just to be careful.
Bob, what if you're done asking questions and you didn't ask certain questions on purpose, and then the bench officers decide they're going to ask all those questions you didn't want to ask?
Yeah. I know.
What stage of the game are you in? Are you in the department's evidence or in your evidence?
I know it doesn't happen.
Pardon me?
But you can object to their questions. I used to object to Zeigler.
Yeah, I used to ask too many questions sometimes from the bench. People would object to that stuff, but I just don't want their objections. Because I wanted to know. But you should probably object, okay? But sometimes the bench can get carried away and taking the case over.
Bias.
Biases, yeah.
Bias on the bench.
So then on page 2 of the handout, there's some tips, suggestions that you can follow on cross-examination, how to ask open-ending cross questions, One of the tips that I have here, and you don't have to use it again, this suggestion is all a matter of your style, is maybe you don't want to lead a question with, isn't it true? Isn't it true? You know, you want to lead them down the path you want to go. Then you have impeachment. If there's information here on impeachment, prior inconsistent statements, and how you confront the witness. And that will continue also on page 3. Then we have refreshing recollection. You have someone who's on the stand and is giving you questions like, oh, I don't recall, and you see it in the statement, and you want to give them a document to refresh their recollection. Maybe, did you say this? And they're saying, oh, I don't recall. Well, here on page 3, it shows you how to refresh someone's recollection with the document or a prior statement that they have, that you already have, where they saying where their memory needs to be refreshed from. And then also you have redirect. Sometimes this is the part where it would be rehabilitation. Maybe you need to rehabilitate your client. Maybe on cross, a damaging fact came out. For example, well, isn't it true you got a positive meth test on such and such day? Or isn't it true you missed the test on such and such day? And the answer is yes. So the department doesn't ask them why, but on rehabilitation, on redirect, that's where you would ask, well, why did you miss your drug test on this day? Or why was it positive? So that's what you would do on redirect. Or sometimes if a new fact comes out on cross-examination, you should be given the opportunity to recross. Do your closing arguments, and then you're done. That's the manner. Now, in between all of this, you have to get documents in, you have to make certain objections, and that's where we will follow on the next page. But before I move on, did you want to add anything to that, Rob? Any questions?
Any questions, though? There's a lot of information that is being left out in between stuff for the sake of time. Yes?
Before we move on to exhibits, Sherry, do you think that Mark A applies when your client's not facing criminal charges, and can you use that red front?
What do you mean? What do you mean if Mark 8 applies?
If your client's not facing criminal charges.
Are you saying he doesn't want to testify?
Yeah, can I use that?
Do you
if my client's not facing criminal charges?
Well,
yes.
Do you want to use that, though?
But do you think it's applicable if your client's not facing criminal charges? What are they asserting their right for?
It depends. It all depends on where my client, does my client want to testify? Would it be harmful to him? So I think it would depend.
Well, what about a situation where you have a client who absolutely would recommend they not testify because it's probably just going to hurt their case. They have nothing positive to say for their case. But since they have a right to testify, they say, look, I want to take the stand. How do you handle that?
I make notes in my file that against my better judgment and experience, I have told him not to testify. And if he really wants to get up there, I lay out all the facts and it's going to hurt your case. And if he still wants to do, the worst thing is to have a client come to you afterwards, or you pick up another client and say, well, I wanted to testify and my attorney didn't let me. I still think it's their child. And as long as you lay it out and in your file, just note everything that's being said. If he wants to get up there,
I'm not asking how to document what happened between you and the client. I'm asking how do you handle that person on the stand? What questions would you ask when they're saying they want to testify, but any question you ask them really is hurting their case?
Well, sometimes though, I'm sorry.
Go ahead.
No, go on.
Well, what I was going to say is that when you have a client and you've already advised him and you've documented your file, like Donna said, and you let him know the consequences, what does he want to testify to? You ask him those questions about testifying. One of the questions, well, for example, what's in your fact pattern? What does he want to testify to? I didn't fail to protect my child because I got one positive meth test. Question could be is, do you feel that you're harmful to your child? And let them run with that. I mean, it all depends on the fact pattern. It all depends on your style. You have to figure out a way that you can get your client's testimony so that he feels he's had his day in court. And sometimes you just have to ask direct questions. Does that answer your question or no?
Well,
Did it answer
I
your
guess
question?
it's one idea, yeah.
Okay, well, that's all I have, is one idea.
Rachel, you want to say something?
I was just going to add, I'm sorry, really briefly, Sherry, sorry. A lot of times our clients are coming in feeling that, the system's against them, everything's against them, and you're probably right, they're not gonna have much constructive to add to their case, but it's just the fact of getting up there and being able to say that they testified.
Right.
So you could keep your questions really short and direct, and try not to wade into the waters that, where they're gonna sink. Also, as you prep them and you're letting them know that the county is gonna come back and cross-examine them, and you give them a real and I'm saying this with this caveat, I know you guys don't have time, a whole lot of time to prep your witness, but this might be a case where you wanna meet before and give them the full show about what the county's gonna ask them, and then have your little direct script that you're gonna ask them on direct.
Okay. Marlene, did you have a question? Okay, moving on to foundations and exhibits. When preparing for this trial skills, since it was so broad, we tried to narrow what would be helpful to people. And one of the comments I received is, some of the new attorneys need to know or be reminded that you cannot argue what's not in evidence. You can't argue what your client participated in if it's not in evidence. So you can't argue he attended this program if it's not in evidence. So following that, you either would have to set a foundation for that by putting him on the stand, him or her on the stand, and providing the exhibits and having him or her testify to that particular type of evidence that you're trying to get in, whether it's a document or some sort of graph. So on page 5 of your handout is suggestive way to lay foundation and get your exhibits in.
Getting along what you said, and I do it too, is that a lot of times in closing, the minor's attorney will, in their closing argument, which is not evidence, they'll sit and argue, well, I talked to my client, and they said this, they're giving you a whole other case that was not presented, so you should really always object that it wasn't, an evidence, and they can't argue, because we let it just go by. I mean, a good hearing officer will know not to really listen to it, but you need to make the record, because minor's attorneys do that all the time.
So to introduce an exhibit into evidence, you will want to first have, the court mark it, ask the court to mark it for identification. And you're going to show it to all the opposing counsel. And then you ask the court, this is courtroom protocol, you ask the court to approach the witness. You approach the witness with that document, and you ask them, what is this? They'll identify what the document is. How do you know this document? And then they'll explain how they know this document. And then you ask them a couple more questions authenticating and identifying that document, and then ask to have that document moved into evidence and wait for the judge to either mark it or any other objections. Any questions on that part? You want to add anything on that, Bob?
No, it's just so important to do that correctly, as far as, telling the court what you want to do, making sure that you have it identified correctly, so then when you refer to it, after that you have identification for it, whether it's, your mother's A or B or C or whatever, so you can do that, and then you move it into evidence. But you have to ask the questions like from the foundation to make sure that it's relevant, to make sure it's authenticated, so the court can make that determination. So many times I've seen a lot of lawyers, even lawyers who've been around for a long time, trying to move something to evidence without having done the identification. Okay, so it sounds silly, but it's true. So you just be aware of
And then then there are some tips here on page 6, suggestions on how to do a direct examination of an expert witness. I'm not covering that part of it today, but it's here in your packet as something that you can refer to or use as a resource or a guide. And then moving on to page 8. And page 8 starts your objections. So on page 8, and I note there's some duplicate objections here. And the one up under objections to evidence, I just want everyone to make a note. Relevance and irrelevant is there twice. Same codes, same authority, but it's just there twice. So you can cross that off. But I look at this as almost a cheat sheet of objections. This can be part of your trial prep as well. You can have the objections there so you can look at what can I say next until you become more familiar with objections. You'll have that sheet there. So you have objections to form, which is really 2 types of objections. You have the form of the question, and then you have the evidentiary objections. And these are categorized here on page 8. And then on page 9 and 10 is just other objections that you may cross concerning experts, or just so to note if objections to misconduct. And I thought that this was important. I've seen it around. You may want to object to a county council if they're way out there. But the reason I put the misconduct of a judge is because I had an opportunity, well, I had the unfortunate situation of being in Department 427, where I had a bench officer who was just really, really crazy. And literally crazy. He would demean the attorneys in the courtroom. He would tell them to shut up. He would ask them questions like how many children you have, where did you go to school, and all of this. All of this is improper. So then you have a judge who tells you to shut up. How do you handle that? You have a judge who's doing improper conduct with you. How do you handle that? You object to that. He told me to shut up. No, I need to learn when to be quiet, and I need to shut up. I said, okay, Your Honor, I object to Your Honor telling me I need to know when to be quiet, and I object to Your Honor telling me to shut up, and I would appreciate it if you wouldn't talk to me in the matter. That's my curative. Or I could ask them, well, maybe you need to recuse yourself if you can't direct me respectfully. So I think when judges do things to you, or a bench officer does things, don't let it just pass. Don't laugh it off. Don't encourage bad acts. Object to it. Make it specific. And you have your authority there too. Now I know sometimes you may have county counsel who is just throwing your client, saying all kind of bad things, misquoting the evidence, mischaracterizing the evidence, you know, saying rape, and they haven't proved the legal term of rape, and all of this. Object to that. And this is your authority here to object to that. So going over some of the commonly used objections here. Let's see where we are. So, well, first, why do you object? I think it's important to note or to highlight the reason you object. You're either objecting to exclude prejudicial evidence from coming in, you're either objecting to protect your witness, your client, or you're either objecting to preserve the record, because if you don't object, then it's considered waived for appellate purposes. So that's the reason that I will narrow it down, the reason why you're objecting to evidence coming in or a question. So looking at some of the commonly objections that it's used, you have ambiguous or too vague or too general. So county, the department, or another attorney objects to your question is vague. Well, what do you do? Do anybody know what, any of the new attorneys know what you do when the judge has just sustained an objection as to it being general or ambiguous?
Rephrase the question.
You rephrase the question, that's right. You keep it moving. Rephrase the question. As well as it being argumentative. Or you can, okay, so an argumentative, when you have that objection, And if the judge sustains it, you can either say, well, Your Honor, it's not argumentative. You can ask to be heard on that objection right away. Sometimes they may not give it to you, and sometimes they may not give you the opportunity to argue it, and sometimes they may. But if they don't, you rephrase the question, make it more factual, a fact, and not argumentative, and move on.
You have a question?
Yeah,
Yes.
it's just quick. Sometimes I have a hard time drawing the line between what's argumentative and what's, you know, a proper question for our clients during cross-examination. Where would you draw that line at?
I wouldn't make it accusatory, I guess. It depends, a lot of it depends on where you are in the moment and what you're saying. Am I accusing them by making it a conclusion, or am I trying to state a fact that I'm trying to
I'm
make
saying
them
when
out?
like county council's questioning our client, and I want to make that objection.
That they're argumentative? Oh, you just say it. What do you mean? You just say it. Also, with county council, they can, you know, misquote a statement. They can be badgering. They can be asking questions to harass or embarrass your client. That's on that sheet too, and you would just object. You know, that it misquotes the witness, or that it's embarrassing, or it's harassing the witness, or it's argumentative. I was talking about more when we ask the question and how we respond when it's objected to.
Sharon,
Yes,
can I just have a second? Very briefly.
sure.
It's perfectly okay if you believe county council is doing that, even if the court overrules you, because it will don't pull it all the time. But if it's really happening, you can say it, because it'll slow the county council down, especially if they're on a roll. It'll give your client a chance to breathe, okay? So you do have to prepare your client that county council and minors council may really question them aggressively, and it's perfectly fine as defense attorney to pose that objection. As I said, you don't do it all the time, but when you do, it stops the roll of the punches, gives your client a chance to breathe, even if you're overruled. So it's okay to do it, but just don't do it every case, every time.
Which goes to my second point about the reason you object is to protect your witness. Okay. So, and then another form of the question when you have another objection comes from compound. You're asking a couple of questions in one sentence. All you have to do there is rephrase and say it one at a time. Isn't it true? No, I'm sorry. A compound question, if it was on, if it's on cross, maybe. Isn't it true you had a positive drug test for meth and marijuana and this? You got a couple of ands, so maybe you can break it down. Isn't it true it was meth? Or, sorry, not isn't it true? Did you get a positive test for meth? Or make them break it down and point it and not put it all together. And then you have hearsay. Sometimes the question, I love hearsay because here we kind of think that hearsay is non-existent. But hearsay is while lax, is still a part of an objection, and we don't want evidence to come in because it is hearsay or there's multiple hearsay. So you will look at where it's coming. If it's not within the exceptions that I have put to hearsay, then it's not hearsay, which is on page 10. So, and then the objection that I see a lot, I mean, whether you see, whether it's argumentative, whether it's ambiguous, whether it's vague, whether it's prejudicial, or even speculation, all come up under 352, Evidence Code Section 352. And that covers the mode and that gives the bench officer conducting a trial wide latitude over what you're objecting to under 352. Sometimes you may hear, I object 352, well, what 352? What? Embarrassing? What? Prejudicial? What? What is 352? And if you don't understand what it was in 352 that the judge sustain, ask the judge what the basis is. Because when you make an objection, it has to be a legal objection. It's not objection overruled. Well, what do you overrule? What was the legal objection? You have to have a legal objection, and try not to make too many try not to make any speak